the next one, torture, both or physical and psychological. And this is perhaps the one, it's a discordance for my international law experts here. It's a discordance norm, and there's like so much jurisprudence that affirms. There's the UN Convention Against Torture, and then there's a twin principle, which is the last one, which is the you should not be treated or punished in cruel, inhumane, and degrading treatment. And then there's the final one, which is corporal punishment. So you see, there are a couple of different things that Article 29 is supposed to protect. So the question that we are asking ourselves, swali tunalouliza katika hii kitabu ni what did we want pre-2010, right? What did we want so that Article 29 becomes to life? If we go back to the CKRC reports, you realize tukikumbuka vile CKRC reports were being created. If we read like the chapter by Professor Ambani, guy in our constitution, walikuwa wameweka mikakati ya, they go to and ask everyone, like every village, they ask, what do you want to change in the pre-2010 constitution, right? And if you read that, the CKRC report, it shows like people are actually saying, these are the things we want to change. So they would mention things like police custody, like unawekwa jela for 30 days, alafu after 30 days, unaletwa before court. In fact, there is jurisprudence showing that courts were actually saying detention begins when you're given the detention order, right? And there's so much. There's a paper by someone called Albert Muma who discusses this. The justification was public security, but my question really was organizing a rally about multipartism a public security question? This is something I really I'm trying to understand while I research more in this chapter. So some of the other things that watu walikuwa nasema tunataka change ni, imagine there were some times where you would be in custody, and this is a callback to Stella's chapter, where because you're umeshikwa jela, alafu you're from labda wewe ni Mkurino ama Muislamu na uko na ndevu, polisi wanakuambia unyoe ndevu. That was actually what was happening. And it is mentioned in the security report that we don't want police officers to be doing this, even when they arrest us, even if it's for just cause, right? So these are the ideals we wanted to put in Article 29, right? So, and the question Mr. Ochiel has asked me is, are we really doing that, right? So I started off showing this 3 years, 1984, 1954, and 2024. And what I'd argue is it's a normalization of state violence. And there's normally a myopic, okay, tunaangalianga ile yenye imehappen tu sahi, but aturudi back in time tuone like what it is that trend even in the presidencies where we're like, that president was good. But if you look at all these presidencies, there was clear violation of these corpus of rights under Article 29, right? So yes, and I really want to look at another part of the book, which is the international human rights normative framework. Mr. Ochiel, this is the assessor. This is what we are using as an assessor, the international human rights normative framework. And for me, I think the African human rights framework is especially important for us. And this is because, first of all, if we read people like Fatsa Ogogo's, even our own Mwalimu Sipala here, the African human rights system ilitengenezwa not just for us to remedy the wrongs in Africa in the 1980s and 70s, like this Wagala situation, but pia ilitengenezwa ku remedy the wrongs that the UN system created and still perpetuate. That for me is so important, that we have to look at autochthony through this African human rights system, right? So the African human rights system has enough case law, right, from the commission to the court. Like there's this commission decision, John Ouko versus Kenya in 2000, right? John Ouko is the son to Robert Oko. And I know Robert Oko is a name where we all know, like he's someone who suffered death because of a regime that just didn't adhere to, or it created laws to make it legal for what it did. So from the African Commission, it ensured, it created, this is a 2000 case, and in 2016, we can see a straight line between these two cases. This nephew, John Oko, he brought the matter because he was a student, he was in charge of the student union in the University of Nairobi, and then he was arbitrarily detained for 10 months. And then the court obviously said that he has to substantiate his claim for torture. But if we read that case and we read another case, which is the African Commission of Human and People's Rights versus Libya, a 2016 case, we see that the African human rights system is especially clear that we, as African states, our onus is higher because we have been for a long time accepting this these atrocities. We can learn from people like Frantz Fanon when he says that post-colonial problem is that elite problem. Those African elites who take power and then they use it for their own benefit and to the detriment of their people, right? So, yeah, I think the African human rights system. There's also the Committee on the Prevention of Torture in Africa. There's the Robben Island Guidelines. All of these are they share, you know, it's a shared knowledge, a shared experience, and now they're shared tools that we should definitely utilize to operationalize this, right? So those are my thoughts on the international normative framework as
as we conclude, what are your thoughts on this trend of charging protesters with terrorism charges and the consequent denial of liberty, nearly guaranteed long periods of detention by the judiciary? Is the article safe in that kind of environment? And then the court also, giving exorbitant bail to protesters. The lady from Nanyuki, I forget her name, denied bail or given exorbitant bail terms, and then she ends up dying in custody. What does that kind of judicial or police practice do to the rights guaranteed by this article?
Yeah, thank you so much, Mr. Ochiel. So, yes, this instrumentalization of terrorism charges is quite telling. And in fact, obviously, we've seen our President Ruto saying that, these are terrorists, calling us. I went to protest in 2024, so I might, according to be a terrorist, right? So it is a weaponization of terror charges, and he's been doing. He said it last year and he said it this year. But interestingly for me, as I was researching, there's a report by Privacy International on counterterrorism and surveillance in 2016. They show that even in the Uhuru Muigai Kenyatta regime, they still used counterterrorism rhetoric to justify some of these violations of Article 29, right? So you think about those Muslim youth, especially the youth who are living in places like Isli, and then someone is just gunned down, Evo to Apple. And you see, there are dual problems here. He's a youth, he's being profiled for his religion, and because obviously the Al-Shabaab during that time had attacked Westgate. So that is the state rhetoric. We are combating counterterrorism and using terror charges, right? So Uhuru used it in 2016, right? And then now we're seeing our president now, Ruto, using it, saying that the youth are terrorists, right? So it's an instrumentalization of this, the provision against. And also for me, if you look at the international law regime on the war on terror and how Western states used it to usurp powers and then also economically exploit people, I see the same rhetoric, right, in this post-colonial state, this these heads of this post-colonial state. And Nanjala Nyabola has an article in 2016 where she traces this problem, this war. She calls it's a war on youth, right? Using counterterrorism as a justifier, right? So perhaps on the bail question, I'd perhaps leave it to you who practices this on your daily basis. But it's true, there are class problems there, and for me, it's even escaping this technical reading. I know in the morning we're learning about remedies from Article 23. We're talking about things like anticipatory bail, which might not be relevant. But yes, so I'll leave that question to you, but Mr. Ochiel, but I do agree that the courts, we are not doing great, they're not doing great service to the people if they themselves perpetuate the atrocities by putting exorbitant fees. Thank you so much, Mr. Dudley.
Thank you, Elvis. I turn to you, Adeline Chelagat, and my question is, what about human dignity? Where's the place of human dignity? If what Elvis has recounted is the situation on the ground.
Thank you, Mr. Dudley. Very interesting. Now, my article deals with Article 28, as has been mentioned, that is human dignity, right? Na swali tunayojiuliza leo ni what is human dignity? And I think that it is important that I, elaborate more on the concept of dignity just before delving into the question itself. And when I started writing on this article, that is the same question that I asked myself. I don't know about you guys inside this room. Kila mtu tu katika, okay, everyone in this room, mejiuliza what this human dignity is, because you can't particularly pinpoint what it is exactly, right? So that we say, nikikuchapa hivi nikuumize, have I violated your human dignity? Probably yes, ndio. But if I'm to mete out harm for maybe 3 seconds, is that violation of human dignity? If I'm to do that for 3 hours, is that human dignity? For 3 days, is that human dignity? Now the 3 days, now the 3 seconds, are they the same? Right? So kuna maswali mingi ambayo tunaendelea kujiuliza, tukitaka kuelewa vizuri sana what human dignity is. And I try to analogize this by using a picture and a frame in a picture. Now, the same way the frame frames the picture, I believe is the same thing to human dignity. Human dignity frames the worth of a person. As an individual, your essence, your character, your story, mahali umetoka, what you do, the kind of job that you do, the type of family that you have, everything that makes you you is the painting. And then dignity comes to frame that, right? So that the painting might change. You might grow up, you might become a big person, you might get a different job. But does your dignity change? No, it doesn't. Does your frame change? No, it doesn't. And that really underscores what dignity is. I believe it is the worthiness. Martin Luther King talks about it and says there's like somebodyness of a person. You are an individual. Inherently, you are worth something. You are not an animal, you're a human being. And so there's something called inherent dignity. And that is what the Constitution talks about under Article 28. It says that every person has an inherent dignity that should be respected and protected. Sawa sawa. So even as you're going on with your ways, you have something called inherent dignity that nobody can ever take away from you. This frame can never change. So my take on where we are as of now of dignity, just allow me to give just a brief backdrop in terms of the report that was given by the CKRC. Now, when we beginning, we had even the keynote speaker, Honorable Gitobi Manyara, talk about the history of Kenya, right? Stella has given us the history. Mogesa has given us the history of the specific articles, and we have seen where we have come from as a people. And I'd say that there are so many instances of violations of human dignity. Just to mention a few, for example, when Mogesa has talked about the 1954, the Mau Mau. And I remember reading this article. It was just the story of, I think, JM Karaoke. And he talks about his time. I really hope it was JM. But then it's a person who talks about his time during the Mau Mau, and this person was detained. And you should really think about the violations that happened. People were not, the violations there were extreme, they were very severe. So, those are instances of violations that were meted up by the colonial regime. Then, even after independence, we still had things like the Nyayo torture chambers that were happening. We had the suppression, for example, of the multipartism, and even people who fought for this multipartism, a lot of people ended up dead. We have so many political assassinations that occur, especially during the time of I think both Mzee Kenyatta, Mzee Moi, as Mogesa said, like when you interrogate deeply this president's time, you'd find human rights violations. And then what happens? People fight. We fight. We say, sisi tunataka katiba mpya. We want to become a new kind of people. And this leads and this births our constitution. And when the CKRC, when they go around talking to people, people are very clear and they say that in our preamble, and just let me read what it says. They say that we, the people of Kenya, aware the governments are created to serve humankind in the pursuit of peace, prosperity, security, happiness, environmental integrity, and dignity of human life. So people knew that they needed their dignity. And then we also have the old people who felt that they were marginalized, together with the disabled people, right? Who felt that they were marginalized and they needed more rights. And then we also have something that I could just mention. So during this time, even as they were continuing to collect, some things were not, they were already standard. They were not very controversial. And those were three things. The first thing being human dignity. The second thing being equity and equality, which I believe Griffins will mention. And the last being affirmative action. So we can see already that it was the people's cry for their human dignity. But then, even after the constitution comes in place, where are we now as a country? Mogesa has talked about, and I think you guys watch your news, right? You've seen the protests that have been happening. You've seen people being gunned down in broad daylight. You've seen people being taken to custody and they end up dead. So many human rights violations. And in my paper, I classify dignity in three parts. So the first one is dignity as a foundational value. This is provided for under Article 10.2, those national values and principles, meaning that all state people, while carrying out, while conducting the activities, they should always have human dignity at the forefront. And to me, that is really the foundation of everything. It's the roots of this tree. Human dignity should permeate, even as you continue with your work. Maybe some of you here, mnaajiri watu, mumeajiriwa. While your employer is doing something to you, you still have that dignity to you. And I think that's a foundational value. And the second way I have categorized it is dignity as a substantive right. And this is what we see under Article 28. So that is the article, the inherent dignity of each individual. And lastly, we have dignity as a normative principle in the interpretation and limitation of right, meaning that even as maybe, for example, the courts continue to interpret this right, or any person decides to limit this right, they should also consider dignity. And I shall elaborate this in, many cases, if time is really not far much spent. So so I just wanted us to have that kind of backdrop. So in my opinion, Mr. Ochiel, is that as of now, there is dignity, but there's still not dignity. I think you take a situation and you interrogate this dignity. And just allow me to mention something. So even if you've said dignity is a bit abstract and you've said dignity is the frame of our essence, we also have dignity being your ability to be able to determine your own destiny. In the first panel, Mr. Levy said that if you want to move from here to Rafiki, for example, and then a person says, no, you can't move, and you ask, why? Why can't I move? And there's nothing like, there's no necessary excuse that they give you. That can be considered a violation of your dignity, right? So there are many instances of this violation of dignity if you cannot be able to determine, to make your own choices, to have that kind of autonomy, kujisimamia kama mtu, useme, mimi, whatever you're doing to me, I don't want it anymore and I want to get out, for example. And Mr. Dudley also hinted to like issues of femicide, for example. You know, these are instances where we have severe violations of human dignity. If you can't be able to determine your own destiny, that's a violation of human dignity. And so my answer will be, this is partial yes, a partial no. We have dignity in the sense that we are free. Dignity in the sense as of now, as we exist, I believe that most of us, we have independent choices and everything. But then in another perspective, if you look at it from a different lens, when we go out there, for example, the suppression of for example, the freedom of expression, what we're seeing from the government, that's a violation of dignity. You walking and being gunned down, that's a violation of dignity. If you're able to interact with the community person and they do something to you, get beaten, that's a violation of dignity. There are so many instances of violations of dignity. And so maybe as I just conclude this part, I'd say that most of the time, as dignity is the foundation of all rights, most of the time when there's a violation of all rights, there's a violation of dignity. So it could very much close tied. So even if ukiumizwa tu kivyovyote, and I mean literally anything, your dignity has been violated. Most of the time it is rare and I think impossible for you to violate a right without violating the right to human dignity. Thank you.
Okay, Mr. Ochiel, if you can hear us.
Thank you. Thank you, Adeline. I want us to look at the good side, and I'm quoting a judge, Justice Mumbi Ngugi, in a case called William Musembi at the High Court. It went on all the way to the Supreme Court, and I was fortunate to argue it there. But these are her words before the High Court. She says, an eviction of the nature undertaken by the respondents does not just violate the right to housing. Encompassed in a person's dwelling is their family life, the ability to take care of their children, their ability to live a secure and dignified life. I think that's what you're talking about, dignity. When they denied their shelter, their dignity, security, and privacy is impaired. Unlike the birds of the air, men, women, and children whose dwellings have been demolished will not fly away and perch on a tree and then begin to rebuild their nests afresh. On this question of forced evictions, some of which would take place in the dead of the night, during the school term, in rainy weather, do you think that the courts have done anything to stop this culture of forced evictions? Do you think they've done enough? Or is there more they could do? And are there any other areas we could point at and say, yes, on that one, the judiciary upheld human dignity?
Thank you for that question. And I'd admit that maybe I'm not so much an expert of evictions, but my take on this would be that from the types of like cases I've seen, so for example, the one from Mitumba village, at that period of time, there was, I believe the judgment of the court was very instrumental. And I think that we can say the court is, in my opinion, trying its best in the sense that it even invented like structural interdicts so that it can be able to follow up on what has been done. So my opinion on evictions will be that the court is trying really. Maybe much can be done, but maybe you can tell us more about that. And in the other, like a subsequent question, has the judiciary tried? I think it has actually. Now we see that when we now move from after 2010, right, post 2010, when the judiciary is interpreting this right to human dignity, they take a very expansive approach in the sense that, so we had give, for example, the case of there was the case of ANN versus Attorney General. Now, in this case, we had a man who was dressed like a woman, and he was arrested, of course, and they searched him, and he was teased and harassed and, basically assaulted. And when the court was deciding on this matter, one of the questions that was before it was, whether human dignity was capable of enforcement. I think this is one of the very fundamental cases that was decided post 2010 and 2013. And the court said, yes, dignity is enforceable and it can be substantiated. So in this case, they really tied it with the right to privacy in the sense that even if we say that, so for example, in the West, the European Court of Human Rights, they tied dignity with other rights. But then in this one, and even the African regional system, dignity stands on its own. And the court was able to affirm this right and say that this person was entitled to their own choice. And the act of humiliating this individual was a clear violation of their dignity. So I think that was a step towards the positive direction. We had other cases, for example, of MWK and another versus Attorney General in 2017, where there was a group of high school students who were coming from school and they were I believe they were drinking, maybe engaging in sexual acts, and they were stopped by the police in this matatu, and they strip searched a lady, and they found her with cannabis sativa, and the media came and they took nude photos of this lady and they were published, and it was this a violation of human dignity? And in here, the court was very emphatic in stating that indeed there was a violation of human dignity. In especially looking at this person as a child, the court was very, do I say adamant, or that it was very vocal in saying that dignity is the center of all rights. It's the foundation of all rights, in the sense that a person at any time should not be able to lose their human dignity. And it even said that then, the question then they even asked is, what is the compensation of a person who has had their dignity violated, right? Imagine your daughter, your sister, even yourself, you're strip searched, your photos are published online. What amount of money would you be asking to be paid?
Okay,
right?
Just on that question of compensation, Adeline, as we conclude,
Okay.
would you say that the president's recent directive that victims of the kind of atrocities Elvis spoke about, the people who've been killed in protests, is it from 2017 or I forget the date, but that kind of directive by the president, the first ever to acknowledge, that these kind of things are wrong, and those who suffered that kind of harm must be compensated. Or even the kind of 3-day inquiry that Parliament held when Albert Ojwang died. Would you say that such measures help to promote, to respect, to recognize human dignity? And is it an approach maybe you would suggest for state officials, to begin to take steps to remedy the kind of violations so that these atrocities do not occur and then they go as if the constitution is no longer there and Article 28 on dignity did not exist? What are your final closing comments with those in mind?
Thank you for that. So I'd take this way in like two ways. The first one is, I think it's a step in the right direction, right? But you've seen so many people saying that you can't be able to compensate a human life, which is very true. But then you say, in a sense, if you can get compensation, I think that's a good thing. I mean, haitatuliza moyo kabisa, neither will it bring that person back to life, but it's something, right? But then I also foresee a situation where, because there is compensation to that end, there might be you see, the way when you like open a Pandora box, like sasa the government can decide to like reach out human rights violation and whatnot. But then the end thing will be like, but you guys get compensation, right? So I see it going two ways. As of now, I think maybe the government's initiative is a good one without going so much into the semantics of it. I think on face value, it's a good thing. But then it, of course, it needs to be deeply interrogated. And then just lastly, as I conclude on that case law, when they said the fact that, you know, no kind of monetary compensation can alleviate the scarring of the soul. And I think that that really frames what dignity is at the end of the day. Although the lady was given 4 million as compensation, many would argue that she deserved more or she deserved less, right? And I think genuinely that you can never speak about. They say the Bill of Rights is the heart of the Constitution, so is human dignity the heart of the Bill of Rights. And that I'd wish to leave it at that and pass it over to you, Mr. Dudley. Thank you.
Thank you so much. We'll step down one article to Article 27 on equality and the entitlement to equal benefit of the law, and equality being both direct and indirect. I mean, discrimination being forbidden in its direct form. I'm discriminating against you because your name is Griffins, and then indirectly, the freedom of religion cases that we saw, where you have a uniform rule, everyone must cut their hair. But then you have a Rastafari student, a case I was fortunate to argue, whose religion, based on, I don't know if it's Leviticus, says do not cut your hair. So they believe that in the Bible. And then, you know, she finds herself at a difficulty. Does she choose between school and religion? Or the Jehovah Witness students who believe in do not be unequally yoked, and they have to attend a Catholic mass compulsory. And so they find themselves disproportionately affected in direct discrimination. So how have these provisions, the prohibition of discrimination in any of its forms, the question of affirmative action, been effective in real life of Kenyan women? Have they been adequately, you know, represented in now spheres of government? What's going on in that area, Mr. Griffins?
Okay, thank you, Mr. Ochiel Dudley. And again, good afternoon. Article 27, that's on equality and freedom from discrimination, is very prescriptive in its wordings. From there, we can depict terms such as differentiation, equity, equality. And when we say equality, we mean equality before the law and equal protection of our inherent rights. Since if we are not equal before the law, we won't enjoy equal benefits of that. Also, we in that prescriptive nature, we are also of the view of accommodation. That is, as human beings, we are not equal, but we have different differentiations. That is, I'm male, another person is female. All my body parts are intact and I have no health issue. Maybe someone else has a disability. Now that is what accommodation means, that even in the sense of me being human, there is still differentiation amongst ourselves. Now, on to the original intent of the drafters of the Constitution, we can deduce this from during the colonial period. At first, it was sort of a fight between the Kenyan people and the colonialists. And now the 2010 was us against ourselves. Now that's why there was the need to incorporate this equality clause in the constitution that is very important, as it cuts across, since it is an inherent right. The original drafters in the term equality, they intended it being of equal protection, even in the courts. Now, when you appear before court, your rights are equally protected by the court institution. Also, what they wanted is, yes, I won't say equality, but I will say equity in now the grounds listed, since the grounds in Article 27, Clause 4 lists various grounds there, that is disabilities, on non-discrimination on basis of gender. Now that is what the original drafters wanted. And we also see a differentiation in the documents that never passed to being the 2010 Constitution. That is why this 2010 Constitution has, I would say, many grounds in a way that clause 4 of Article 27. Also about the liveliness of this Article 27, it is slowly progressing in that there have been these measures, like now when I come into the affirmative action, and also it states that there must be legislative actions that must be taken care of in order to realize this right. I'd say that it has progressed in a way that the 2/3 gender rule was not there previously, but now it has been incorporated here. Now to mean now this now I mean in the gender parities and achieving equality in that sense. As at now, also, though we are yet to get there, but we are slowly reaching there, as I define Article 27 as a right that we will progressively realize it, but that can only happen with slow and steady realization of this right. That is through even the interpretations of the court. That's why even in the case of Eric Gitari, we can deduce that from the dissenting opinions, we could, Justice Ibrahim also heard of, when dissenting, he was of this idea that they were, okay, this is controversial, but in this context, it's very relevant, where he said that in his dissenting opinion of Justice Ibrahim and Justice Ouko, that even in the human nature, that they were not discriminated, not to register the Eric Gitari from that non-governmental organization. Now that places this right on this peak, that we have to see it from an inherent human right perspective. And that's, as I conclude, also on what Mr. Ochiel has said on religion, that also Stella was talking about, is also a ground not to be a ground in the Constitution that does not allow discrimination directly or indirectly. Seeing that time is far much spent.
Okay, so just one final question. Griffiths. We're talking about progressive implementation. We're 15 years after the Constitution. I mean, when is the start date? And then the prohibition, some of those measures require steps to be taken, like policy, legislation, if you look at 27.8, but others can be done immediately when it says do not discriminate. Is that also progressive?
In response to that, that can be immediately achieved in the sense that you don't need, that will infringe, like after I've now faced, like I've been discriminated and gone there. Now that will supersede that, but I'd say that in response to that, it can be implemented immediately.
Okay. Thank you so much, panelists. I will now turn to the audience for their questions and their comments, and Melissa would assist us with that. Thank you for the enlightening discussion of Article 27, 28, 29, and 32. Perhaps the audience could give our panelists a round of applause.
Yes, when you ask your question, thank you, Ochiel. When you ask your question, you face the camera so that people can see you. And then you say your name and where you're from.
Good afternoon. I trust you're all well. My name is Nadia Rashid, and I'm a finalist at Kabara Law School. I'd say congrats, like it's been a great evening. And I'd like to ask my question, nimuulize Stella, na pia Mr. Ochiel Dudley, because I believe I read a guest post of his with regards to the Supreme Court's judgment on the right to inheritance to children born out of wedlock. So I think when I went for my judicial attachment, I asked myself, why is it that we don't have an appeal system at the Qadhi's court? But then recently I got an answer to that. The answer is just in the Quran. Because in the Quran, we believe Quran and Sunnah, which are Sunnah is the acts, wordings, and silent approval of the Prophet Muhammad sallallahu alaihi wasallam. Those are it's the final. So ukienda Qadhi's court, as the constitution states, Qadhi's court wanazingatia mambo ambayo yamepelekwa au utata wowote uliopelekwa kwa kadhi ambao unahusiana watu walio katika dini ya Kiislamu, na inaangalia hivyo based on Quran and Sunnah, mpaka kwa judgment zao they quote Quran and Sunnah. So that answered my question. But then sasa mtu appeal akienda high court, is it that Quran and Sunnah inaachwa pale nyuma? Is it that this question changes now? That was like, I literally asked myself that niliposoma hii judgment, inheritance by the Supreme Court. Why is it that Supreme Court sasa bado inaangalia Quran and Sunnah na pia hakujakaa kadhis pale Supreme Court? Like I asked myself such a question. Halafu sasa hii judgment waliotoa, it's binding to the Qadhi's court. Now, what impact does that have to the right to religion and everything with regards to that? Thank you very much.
Okay, thank you so much. My name is Nelly Ptiso, and a 3.1 student, and also the Kabrak Law School president. And I have one question to the discussant, Ms. Adeline, on the right to dignity, Article 28 of the Constitution of Kenya. And in our previous panel discussion, where we had our Professor John Osogambani, he said that if he was forced to define the word human rights, he'll define it as dignity. And I tied it to the same to this panel discussion. And while I was trying to define on my own self what is really dignity, and I came up with the idea that it is something like self-worth. If someone reduces your self-worth, then that's dignity degradation. And so my question is poverty just an economic issue, or is it also a dignity issue? And if it is an dignity issue, does the government have has a role to eliminate extreme poverty in schools or anything? For example, if a student comes at Kabarak University and maybe he has no fees, the clothes are not, he can't really afford enough clothes, and that can reduce the self-worth. Does the government have any role in ensuring that, at least to eradicate this extreme poverty in such cases, in case it is a dignity issue? Thank you.
Good afternoon. My name is Seth Kabiru. I am from the Catholic University. My question is towards the ideal of Article 28, regards to dignity. It's my proposition and also my understanding, even reflecting on the most recent issue on Albert Ojwang, the virtue that society chooses to allow for dignity to be very variant. I believe one of the things that were quoted as a means towards the curbing or even the realization of dignity for people is the virtue that we see the Senate took a 3-day hearing to inquire on what had happened to Albert Ojwang, which is notable, which is very important. But in those same proceedings, a senator from the Northeastern rose and stated that a massacre had occurred in that very area, but nothing was done. I believe there is a need for the realization of dignity, but as well, it is my position. I think I'm also opening it up to a point of discussion. Can we really say that dignity is being found, even with these curbing measures? Can we really ascertain that dignity is not being given to the society to whom is seen to deserve dignity, and to those whom do not seem to deserve it is taken away? Yeah.
More questions, comments? We want to hear from everybody. Mama Matuko. Mama Melala. Waze. I'm coming this side because I can see Mama Wengi. I know there are questions here. Are there questions here? Yes. Joyce, I think I've mastered your name now. Wonderful. Oh, okay. You also have a question. So you pass it, then.
Good evening. My name is Joshua Kebati from Egerton Law School, and I have 2 questions affecting religion and equality. The first one, it has been invoked from the case of Mawasi versus Fatuma and 2 others, which said that the right to inheritance, which outlawed that the Muslim, I think I don't know much about Muslim, but it's a Muslim law, which was saying that the children who are born outside the wedlock cannot inherit. And from what I understand is that in 2010, 68% of the Kenyans consented to the constitution. And they say that the constitution is the supreme law of the land, and it binds all people and state organs. But now we find that the same constitution, it is conflicting with some religious beliefs. So my question is, what happens after we give our consent to the constitution to lead us the way it wants, after we find it, and now we find it that it is in friction with some of our beliefs? That's the first question. Secondly, is about the president's action to build a church in State House. We all know that Kenya, from Article 8, Kenya is a secular state or a neutral state. And Article 27 speaks about equality, which means that if you have a church in State House, we're also supposed to have a mosque in State House. We're also supposed to have that. If from my community I'm worshiping under a tree, they should also plant that tree for all people so that it can be included. And from Article 133.1, the president is a symbol of national unity, which means that state house is also a symbol of national unity. So what happens when the president decides to give this autonomy to one religion at the expense of other religions? Thank you.
Hi, everyone. Hi. So my name is Edgar Ruto. I'm a student here at Kabarak doing computer science. My question is directed to Elvis. So with the rise of data surveillance and cybersecurity infringement, how does Article 29 apply in the context of technology and emerging cyber security infringement, such as people who are being tracked through their social media and things like that? So would you care to explain? Thank you.
Nimerudi tena, hamjambo. I'm from community. I deal with the real estate business. My question goes to beliefs and whatever religion at 32. There was a fellow who called me, he wanted to sell land. And he mentioned that we are selling this 100 acres, not far from here, but strictly the following tribes should not be allowed to buy here because they practice night running at night, and we believe people it may cause chaos. Now I wondered if it's a willing buyer, willing seller. These are the exercise. Even if someone runs at night, it does not harm you. What is the issue? That's aside. My friend on Article 29, you had the president alluding to anticipatory bail. But I think it's a good practice for legal team, isn't it? And my friend here, Masese, I've been going to court as a human rights defender on writ of habeas corpus for those people who have disappeared. You just passed by about anticipatory bail. I want you to shed light on that. Thank you.
Okay. Okay. Good afternoon. Good evening. My name is Paul Masese. I work for a civil society organization called Center for Enhancing Democracy and Good Governance. And I'm happy to be here. When he talked about night runners, I felt like I should not introduce myself. Because the community I come from is associated with that practice, though it's not true. I can confirm. First is to say that this is quite an eye-opening panel. For the first time, we begin to feel that indeed there are certain things being done, towards realization of those rights. But I got the sense, it's just a comment, that we are speaking more to what the courts and law are doing towards the realization of rights. And there are other things that are happening all around us, that are pushing the needle a little bit forward. I'll pay it slowly, but I would say that there are bits and pieces here and there. I speak more to right to dignity because I'm quite passionate about Article 43. I know at some point maybe you'll discuss it, but when you think about everything, Article 43 would give the true meaning to human dignity. I'm Catholic. There is an encyclical, I think, John Paul II, about how poverty takes away human dignity. And many of us, if you look around, the people you were with in primary school, in high school, who performed quite so well, but perhaps did not make it to sit here in this good place because their families were not able to raise school fees. So that's why government came up with programs that would enable, children from poor households to access education. The essence of it, according to me, would be devolution. If devolution were to work, then would move a little bit faster towards the realization of the right to dignity. But I would want to, maybe, if any one of you could comment on how corruption is taking away or is slowing the pace towards not just realization of the right to dignity, but indeed all rights. Because from where I see it, then one problem that I think we have to deal with if we are to realize human rights is anti-corruption. Because corruption takes away people's choices, and corruption makes it possible for government to normalize violence. I liked your assertion that over the years, there's been a tendency of the state to normalize violence. And we are at this point where perhaps majority of us in this room may not be willing to participate in another demonstration, even if it were to be called. So do you believe that corruption actually takes away people's choices and therefore slows the pace towards the realization of human rights? And what then do you think can we do within and outside the law to deal with corruption? Thank you.
So there's a request from the audience that we hurry up, and I agree. So let's hear from Joyce, and then our discussant, our panelists can give us a quick parting shot. Then I'll make some announcements on nice things for you, your audience, and then we close. Karibu, Joyce.
How are you again? I'm Joyce. I'm from the community law school because everybody here is from a law school. Yeah. I want to talk about Article 29, where they said about detention without trial. I would like to ask, because most of us in the community, we face this problem of being detained and we are released even without the trial. So do the police stations and the police officers have a right to detain some of our people without a trial and releasing us without a trial? And for how long has a person have to stay in a court, or not in a court, I mean in a police station, not even in a police cell, in a police station before being tried? Because you can see maybe you're arrested on a Monday, you stay up to maybe a Friday. If you ask, you are told, oh, OCS hayupo. Mwenye alikushika hayupo. Mambo. We are told so many things. So I would like to know how long, and do they have the right to put you there? And if they have the right, do you also have the right to sue them? Can you go, ikifika wakati wa kesi yako, usimame useme, mheshimiwa judge, mimi kwanza I would like my case to start kwa sababu nimefungiwa kwa muda bila kupewa trial. Then another question is about Article 28. I think it's about human dignity article, where we find that there is a saying that goes that spare the Lord and spoil the child. Me as a mother, you would find this article inaniumiza because nowadays ukiguza mtoto, ukiguza tu mtoto hivi, you're in for it. The child anakustaki. And most of you nyinyi wenye saizi mtoko mbele yetu, wenye mnasomea hiyo law, na nyinyi tu ndio mnaitengeneza, inatumiza sisi. So I'm asking you, especially you the students, what are you doing about that article? Munaendelea kutufinyilia sisi wazazi na sisi ndio kwa community. Unajua ile mambo yenye mnafanya hapa shule, the things you do here, and then you bring them outside there. Me as a mother, I cannot tolerate. I'll beat the hell out of you. So after beating the hell out of you, are you going to sue me? So are you going to let this child haribike na ulimwengu wote uharibike because you are the people who are writing these laws. Thank you.
Over to you, Ochiel, to wrap us up.
Thank you. 28 hata si mbaya sana. Ile mbaya ni 29, the one that forbids cruel, degrading, and inhuman treatment. And that takes me straight back to Elvis. A minute for any question related to you and your final comment.
Okay, thank you. Yeah, thank you so much. Yes, there's a clause on corporal punishment, right?
Yeah.
29F. That interestingly, tukisoma the CKRC, in fact, people's views were like, no, corporal punishment works. Like, don't remove that. These were actual people's views, but we still find that it is prohibited against. But you know, so there's corporal punishment and utachapa ukikuwa police station na yenye utachapa ukiwa na parent wako. So I think here we now can think about things like threshold or proportionality. Ni kuchapwa gani ni corporal punishment yenye inaongelewa kwa article 29F. And there's like so much case law on this. There's one case where a child alichapwa hadi macho ikatoka. Unaona sasa hiyo lazima ipelekwe koti. Lakini kama ni kuchapwa strokes 5 10 hiyo, I think definitely yes. So Edgar, my good friend, asked about data surveillance, and yes, so what came to my mind is, I don't know if you guys remember when in Twitter, tech people and law people came together when they were taking people and they were arbitrarily detaining them, and we don't know, they were being held incommunicado. And then the tech people were like, this is how we can get them, showing GPS and stuff. And then the law people were like, oh yeah, it's against Article 29. So I think my answer is, so obviously, yes, the government using Safaricom are degrading this right, but ourselves, we have already created ways where we can. I think I would love to see so much more collaboration like that, right? So there's question by Joyce on police custody. So I think the conversation by Article 49, kesho, itajibu all the procedural requirements, ukishashikwa, like, so the preliminary answer is yes, 24 hours tangu umeshikwa, unafaa kuwa umepelekwa mbele ya judge, right? So, but that's really a myth. Ukishafishikwa Friday ni hivyo, right? So, and anticipatory bill, perhaps Mr. Ochiel can answer that. But my final comments are this. I could say that Kenya should ratify the AU Convention on Ending Women and Children. I could say that we should operationalize the National Coroner Service Act, so that you can know how someone died. I could say we should operationalize the Prevention of Against Torture Act. I could say all of those things, but for me, the important thing is what was mentioned, that we should leave the logocentric here. And this is from Derrida, if we are to truly deconstruct, right? Tunafaa kutoka from this legal, like myopic way of looking at it, to go back, as he's saying, there are already needles being pushed, right, in other places that are already answering how best we can realize all of these corpus, or the heart of the Constitution, as Adeline put it. So
thank you so much, Elvis. I come to Stella. Still on the question of the State House Church in a minute, and your final comments on the other issues.
Okay. Thank you. I will start by responding to the questions that I was asked. I will start with Nadia, whose question was on the impact of the judgment to the Muslim community. And as I stated earlier, I agree with Harrison Bori's views on it, where he was saying maybe we should have considered what the Muslim law says about it more, rather than, not imposing, purely using constitutional values, because that's an infringement of your beliefs and the laws that you use to govern personal life. Yes, so I do believe the impact is it infringes on the beliefs and freedom of religion of Muslim communities. But I'd also like to hear Ochiel Dudley's
contribution on that issue. On the issue of willing buyer, willing seller, I believe, okay, my answer is that I don't think even is a right to freedom of religion or belief. I believe it's bias against another community, which your neighbor there has said even the allegations might not be true. So I think even in litigation, maybe that would be more of discrimination, bias against a community rather than somebody else's belief about what another community is doing. I've also taken his comment on noting that there are other things that are other factors other than law and jurisprudence that is helping to promote and achieve the progressiveness of this Bill of Rights that we're discussing during this conference. So we'll consider all those factors in our chapters, which you should be looking forward to reading them. Yes, I think those are the only questions addressed to me. My closing remarks are, as Mogesa has said, maybe the solution lie beyond the law. If I would take my rights, for example, we should start by maybe amongst ourselves accommodating each other. I think that pushes the needle of us realizing this right. If it doesn't cause harm directly to you, I don't think it should be an issue for you to allow someone else to manifest their own beliefs. For example, even from the cases we were seeing, if maybe schools will just let Muslim students wear hijabs, they don't have to be uniform, that's their belief, we would not even have been in court. So I think accommodation of each other and tolerance is very important. Yeah, those are my final comments. Thank you.
Thank you so much. Let's go to Griffins. Any response to one of the questions asked to you and your final remarks in a minute or so?
Okay. Okay, thank you, Mr. Ochiel. I'll tie my answer to Mr. Masese Paul on does corruption slowing down the realization of these rights that we are talking about today? Yes, I'd say that, and I would also tie it to the international frameworks. That's the ICEACR, that's the International Convention on Economic, Social, and Cultural Rights, that these rights, especially Article 27 on equality, is linked with we can link it to socioeconomic rights, because when the resources are consolidated to one place, it deprives others of, like in the earlier session we were talking about when Mr. Baraza here raised that issue of boreholes. When boreholes are built in other areas and are not built where other people who are still humans, it infringes that right of equality. Now to Joshua's question on the church, building the church in State House. First of all, I would like to hear Mr. Ochiel's remarks on that later as he concludes. But I'd say that in a way, someone could argue that when a church is built in State House, also a mosque and other like shrines need to be there. But to respond to that, we also need to measure what the intention of building that church is. And yes, at some point, to some extent, it will deprive others, since, like, let's say, since the way my brother Paul has put it, like maybe if I'm a Muslim and I go there, where will they accommodate me? That's a conversation that we need to keep it going. Thank you. Also, now on to my final remarks is that affirmative action and positive discrimination are important and can be achieved immediately. That is to redress that issue of 2/3 gender role, and also other, like, for the disabled people. That's my parting shot. Thank you.
Thank you so much. Adeline, wrap it up. Your response to the questions posed to you and your closing remarks.
Thank you for that. To briefly go through the questions, as our president asked us, is poverty an economic thing or a dignity thing? And you tied it with socioeconomic rights, and I believe there's also a tying of socioeconomic rights. Actually, the Universal Declaration of Human Rights and Article 22 is very explicit in saying that socioeconomic rights are indispensable to the realization of human dignity. The way they talk about vitu kama health, vitu kama nyumba, when you miss these things, you miss your dignity. So I believe that poverty, first of all, is just an ill to mankind. It's can be said as, the source of all problems. But I'd say that poverty is an economic thing that in turn leads to a degradation of one's dignity. And I think that's very important, that we fight poverty. And also say, in terms of dignity being selective, and you should really join me on this panel because I really liked your point. And in the first panel, remember we said death to the status quo. That's the thing. Kuna watu wengine ni kama wako juu ya wengine. And I think this is so much to the political class. Na watu ambao wako na pesa, right? They think they are better than everyone else, right? Because you have some selected power, which I think it's human nature, but then it's even more like it can be witnessed very much in African societies. The way we have tumewainua juu, mtu akikuja au mheshimiwa karibu mnalala chini. I think there's just, this is a human being. I'm a human being. You have dignity. I have dignity. End of story. So the minute we stop glorifying these people is the minute I think we restore back our human dignity. So I think that dignity is indeed selective, but it shouldn't be. You should be very radical. We mwenyewe unafai kujiaminia, you matter as much as the next person. And lastly, in terms of like the spare the rod, spoil the child type thing, I think, yes, venye tu Mogesa ameeleza, kuna kuchapa mtoto na sasa kuna attempting murder. There's one unachapwa and you're like, ni kwenda nimeenda. And I think that is what the constitution really wanted to fight against. But then normally, even as you beat this child, you can argue that you're instilling dignity to this person because you teach them to have good manners. And Mr. Ogat, I think in the session, said that the problem with Kenya, by the way, ni tabia mbaya. I don't think that dignity is tied to economy. I think you can be poor and still have dignity and still have good manners. It's this scarcity mindset ya kukosa. Nikikosa lazima niibe. Lazima wibe. Just do your work as an honest person and get your little, right? Of course, tunaweza sijui capitalism, sijui nini. But to just wrap up, I think that you should know that uko kwa hii dunia peke yako. You have the person next to you. Na vinye like you have dignity for your own person. You remember we said the frame. Pia huyo mtu kando yako akona the same dignity. So I think that if you live with that at your forefront, even as you're interacting with other people, then we will foster a society that upholds dignity. Thank you.
Thank you so much, panelists and colleagues and the audience, community members. Thank you too for the help, Melissa. Just one last thing about the Nadia's question, which was directed to Stella and I. I think that the issue is in Article 24.4 and 175. Article 24.4 says that the provisions of the Bill of Rights will be limited on equality, will be limited to the extent strictly necessary for the application of Muslim law where before the Qadhi's court, against who? Two persons who profess the Muslim religion. Over what? On personal matters, marriage, divorce, and inheritance. So you can, as a Muslim, go to the Qadhi's court and seek divorce and seek succession, as opposed to going to the mainstream courts. Then when you go to the Qadhi's court, then you find the jurisdiction of the Qadhi's court. And the jurisdiction of the Qadhi's court, Article 175, is limited to questions of Muslim law concerning personal status, marriage, divorce, or inheritance, where all the parties profess Muslim religion and have submitted to the jurisdiction of the Qadhi's court. So there's a balance there, a personal choice for the parties to make. Those who want to apply Muslim law to their personal matters go to the Qadhi's court. Those who do not want, go to the High Court. And that election is there. Thank you so much, colleagues. I think we've had a terrific session. I've learned a lot from you, and it's been an honor. Thank you.
Thank you. Thank you, panelists. Round of applause. Yay. You've done well. Even the audience, asante kwa maswali and the comments. And I had encyclical. You know, people don't quote the popes, even me, you know, as a Catholic. Anyway, we have come to the end of the day. Nawashukuru sana. I just have some announcements. Watu wa basi, kesho asubuhi, same time, Shell petrol station near Masai Market. I hope you know where that is. Watu wa basi, 7:30. Also, after this, kuna chai, and then the bus will be waiting for you just here. By 5, inaondoka. So, sichukue maselfie mingi, and then you're left by the bus. Number 2, there are some books for you, not the students. Sorry, our visitors. On your way out, utapata, there's a stand there. Vitabu vizuri for children and for us, yeah, know your rights, governance, imeandikwa na lugha isiyo so complicated. So they're free. So you just pick and you go. Then there's one I've seen is a coloring book. Imetengenezwa na wanafunzi wa primary. So please pick that. A gift from us. Your way out. And then
No. So yeah, thanks so much. So let's pray. Our Heavenly Father, we thank you so much for a wonderful day, for a wonderful first day of the conference, for the different panels, specific this panel, all that we've discussed. We ask you to continuously enable us to achieve these rights, to fulfill them, and may you continue guiding us, oh Lord. I pray in Jesus' name, amen.